just by drafting a set of laws and then having them adopted universally. But if the claim is that we can change things a little bit at a time, right, then I'm still relatively optimistic. So thank you, and that's it.
So this is actually very, very good news because apparently lawyers can change the world at a wholesale level, but they can change it at a retail level, which involve lots more work. And so this is, I think, generally very good for us. So Kevin has graciously agreed to take questions. If you want to ask questions, we have 2 microphones in the room. Come up to one of the microphones and just say your name and identify yourself as a student here or whatever else it is you do. Thanks. Thanks, Kevin.
Hi, my name is Ben Stone. I graduated from law school in '04. This lecture is really near and dear to my heart. I left my job as a corporate litigator last year, and I'm now running a startup social enterprise working with women in Rwanda. We are incorporated as a nonprofit, but something that I think a lot about is how is the legal framework set up to really encourage social enterprise in today's world, because I personally think that social enterprise and using enterprise-based approaches to common development challenges is the way to go. It promotes sustainability, ownership, and all that stuff. So I was wondering, one, what do you think about social enterprise as a way to pursue development? And 2, what do you think about the 2 common corporate forms that we work with right now? So we have the nonprofit and the for-profit. I personally don't think either are efficient in promoting social enterprise, and I was wondering if you thought there was a hybrid that might be feasible, anything like that. So, thank you.
Thanks. That touches on a very interesting question that actually I've become particularly taken with over the past few months. Specifically, the question about the appropriate organizational form for organizing these kinds of activities. The nonprofit form traditionally has been viewed as optimal for these sort of public benefit activities, right? Because especially if you're trying to attract donations, right? Why would you give your money to a for-profit company to go and hand off to some third person? You worry that they'll chisel, right? They'll skim too much off the top, right? So some people, though, are saying, well, you know, if you can specify their entitlements to a profit carefully enough, if you can and measure the delivery, the services they're delivering carefully enough, then maybe it would be appropriate to have for-profit companies engaged in these sorts of social enterprises. And so that's, I don't know if this was what was driving your question, but the most recent example has been Google, which has set up its own sort of social enterprise vehicle that is, you know, they deliberately decided not to incorporate as a not-for-profit. They're not a charity because they didn't want all the restrictions that come with charity. And, you know, they want to be able to attract people with all the stock options that, you know, Google can grant, and you can't do that as a charity, not-for-profit entity. There are hybrids, intermediate forms that sort of limited profit entities, and so last term I had a student who's sitting over there, actually, Michelle Scholastica-Paul, who was writing a paper on the virtues of some of these hybrid entities. I have to say I'm not quite convinced, right, yet, because I do think there's a, but I'm still open to the next draft. Because I just think it's too difficult. I don't know if it's possible to measure the public benefits that are being delivered by these organizations. And if it's not possible to measure the benefits, then there's a significant risk of the chiseling. And so my personal opinion for the time being is that the not-for-profit form still makes a lot of sense, but where you do want to have the advantages of a for-profit entity, you can outsource to for-profit agencies, right? So you can hire the consultants, you can hire the accounting firms that are for-profit entities, which, you know, and do things that way. But this is actually part of an ongoing research enterprise, and in December I'm hoping to have a conference actually on this very question, because, you know, especially in the microfinance arena, it's becoming a difficult one. So sorry that's not a definitive answer, it's just you caught me in sort of mid-thought.
Thank you. My name is Richard Field, practitioner, graduate. I also chair one of the committees in the American Bar Association, the United Nations and International Institutions Committee. And I wondered along those lines, my sense was that the kernel of your argument was focused on the World Bank and basically bullying countries into setting up certain practices, and that's happened over the years. But there's other dimensions of this, and I wondered if you were intending to cover those dimensions as well. And that would be, for example, the United Nations, which comes out with a treaty, a convention, a model law, and there are developing countries that say, you know, internally, we would never be able to enact our own law because of internal dissent, but we can enact something coming out of the UN because all sides see it as more neutral. And there's a benefit to that, in addition, being part of the world community. The European Union, for example, that is well known for having standardized things, they're very successful going out to developing countries and other countries around the world, Eastern European and others, that want to be part of that world. And in terms of experimenting and all, I'm even thinking of states' rights, state laws versus federalism, and there's a whole different dimension of that, whether it's appropriate for states to experiment versus laws to be federalized. And we've seen all sorts of things there. Are you intending to cover those other angles, those dimensions, or are you really looking at that World Bank type situation?
I think I'm actually a pretty radical contextualist, so I would intend to cover those dimensions. I think certainly logically the argument would extend to any effort to have the same laws, especially the same words, apply to every country. And so if the claim is that that's the best you can do for those countries, then I think that can't be right. Now, if you're saying as a pragmatic matter, that's the only way to achieve any sort of reform, that might be a different story. That's possible. But if you want to argue that that's going to generate good law, then I think that's a difficult argument to sustain. There's also going to be the question of the legitimacy, right, of the sort of these global actors and the legitimacy of the products of their activities when typically developing countries have a lot of trouble participating effectively in those fora, right, having their voices heard. Now just trying to think, there aren't many fora that matter, I don't think, in which developing countries are happy with the amount of voice that they have. So if you're thinking of the WTO, for instance, it's actually proven to be very difficult for developing countries to exercise their voice effectively, have their interests heard. So I'm not actually particularly comfortable with those, with the solutions the one-size-fits-all solutions that emanate from bodies aside from the World Bank. No, so I did intend to cover those as well.
Hi, thank you. Christopher Rogella, I'm a 3L here in the law school. You mentioned or suggested that perhaps we shouldn't worry about things like a 30-day formal delay in setting up a business if there's a 3-day informal workaround. Right. You also suggested that one of the things as lawyers we can do is discourage corruption where possible. Are those necessarily reconcilable positions? Or in other words, how do we tell the difference between nice, efficient, good informal workaround and bad, evil corruption if we're rejecting universalism?
Now, first of all, I'm not sure that my student was suggesting anything corrupt necessarily, so just to protect her interests. And more generally, workarounds that involve the use of lawyers as opposed to doing it yourself, I don't think are inherently corrupt at all. I'm sure Ricky would agree with that, right?
We need to create value in some way.
Right, exactly. And that is the World Bank studies explicitly exclude the use of lawyers from their analysis. But you're right. I mean, that's sort of dancing around the question. Do I mean to endorse corrupt substitutes for formal legal reform that involve corruption? I guess part of my answer would be that it's not necessarily for us to decide that what counts as acceptable forms of corruption and tolerable levels of corruption should actually be decided on a local level, right? If you survey the general population in a country and ask, are you comfortable with this, that the lawyers have an in with the registry office? They say, that's fine, but